that, within ICANN, we make a lot of the rules about how the data should be used. We don't hold any of it. It's held by somebody else, by many other entities. And if you are in a position where you have to grant access based on certain rules and regulations to that data, to violate the privacy, to make sure that to give out data that is otherwise not visible, there's a cost associated with that. And the question is, who pays that cost? We have contracted parties that are in business and actually would like their shareholders or owners would like to actually see a profit. But there's huge costs associated with managing this. How do we do that? How do we balance the needs of privacy, the needs of access, and the costs associated with it in process to end up with something that meets a good buzzword in ICANN's terminology, the public interest, whatever that is.
So I've asked you a question, and you've answered it with a more difficult question.
I think we have to go back to that basic, although we have not defined public interest. We need to consider it, and we need to have some consensus definition of what the public interest is, so we know to what extent we can impose costs on either people requesting data or the people holding the data to make sure that we have reasonable access when it's warranted.
But isn't privacy always in the public interest?
No, I don't think so.
Okay. But that's, I guess, another piece of the balancing
as I
puzzle
said,
here.
we have lots and lots of entities within the internet world who are there for no good, by virtually any definition of no good.
Right.
And I don't think your privacy should be protected if you're one of those.
I am not, but thank you.
As I say, we're not sure about
But I think that some of the up to no good is done with who is information, which raises issues as well. So there's for every action there's an equal and opposite reaction, except they're not equal and they're not opposite. So Deborah, what is your thought on all of this?
Yeah, no, I think I know we're using very subjective words because we're having a casual conversation, but let's role play a little bit. Let's say you're a government who thinks, oh, you're a journalist, you're up to no good, I have the right to, you don't have the right to privacy because you're up to no good. So I know that's not what you were implying here, but I think we have to look, no one, even the most vocal privacy advocates in the world don't think privacy is an absolute human right. There's limitations. They have to be for legitimate purpose. Those are outlined by law. So I think we have to look at the frameworks, and I think due process is important, and looking at what are legitimate restrictions. And that's actually not a privacy violation. That's something that happens in accordance with law for a legitimate purpose. It should be necessary in proportion to that aim, and it should be the least intrusive measure possible. And so I think we have to look at both the privacy rights, these public interest rights, which might include national security and public order and different types of issues that are actually pretty broad as they are, but they're defined, and then see how do we find a solution that reinforces both. And this might be an unpopular opinion, but there isn't in that equation the right to profit off of people's data. And of course, that's what makes the economy go around, but I don't think that should have as equal, and I'm not saying that's what was proposed here, but that's not a consideration on the same level. And I think in today's world where we see enormous profit happening off of people's data, not referring to ICANN here, I'm thinking more of the large internet companies, to be complaining about the cost of implementing GDPR when an organization like my own, which is a nonprofit, also has to implement GDPR. We had to figure out what we were doing on May 25th, 2018. And so I think there's costs involved, but there's costs towards the public interest. And when you see the ways that companies are profiting off of data, and to hear, well, it's really expensive and hard and it takes time. Well, yeah, it takes time to get it right, but if the goal, and I'm not saying that GDPR is perfect, but if the goal is to get towards a better end, that's something that we should all work towards together. And I don't think it's black and white, but I do think this idea that like painting privacy is like an absolute right that people are saying shouldn't be restricted, I don't think that's fair. And obviously there's reasons to restrict it, and there's due process, and there's transparency, accountability, and oversight of those different types of restrictions. And as a human rights person working in human rights, we support that. It just has to be according to different the principles that are outlined in laws and in different jurisdictions.
Right. And I was just being provocative by saying that, I was hoping to be thought-provoking, maybe it was just provocative. But in any case, you raised some interesting issues about the scope of GDPR, and certainly, one of the concerns around data protection laws is the big data companies and the companies that have found themselves with piles of data and then figuring out how to monetize it, and whether or not they have a right or at least they have an opportunity, and how you balance that against the right of the data subject. And I can see there that in essence, the cost of GDPR is kind of the cost of doing business for them, because they are data merchants in a sense. And I worked with some startups a number of years ago who were doing things entirely unrelated to the data they were collecting. For instance, they had a home inspection app where you went through it and you ticked off all of the home inspection things. But then they realized that they had hundreds of thousands of records ultimately of people's home inspections. And well, that was an interesting thing, because they did things like enter in what the cost that they paid for the house was and where it was, what the address, and they could, that data, even those two pieces of data alone are worth money if you have a lot of it. But so let's, a mythical internet company, we'll call it Bookface, can, the cost of implementing GDPR, don't feel too bad about it at all either. But there's also the collateral damage issue. I don't know if, APC may have felt good about it because at least it advanced your objectives, plus it was complying with the law. My law firm, which is only in New York but has clients in the EU, is also, although most of our clients are not, is also implementing GDPR, and it has been a long and very expensive process, because it's a very labor-intensive and very kind of deep process that you need to get into if you really kind of do it by the book. So, to some extent, a problem I have with GDPR is the level of what I, kind of collateral damage, and that maybe there is a need for more nuance in how you look at data protection laws between those who monetize data and those who just end up as data stewards, which of course is still a very important thing. And when you look at the other side of data breaches, it's very important that that data stewards act responsibly, not just in terms of data protection, but also information security, which is a part of data protection as well. So it doesn't really end up with a question, but again, yet more a piece of the balance. And I guess, from this point of view, how do we use this to actually improve trust? Is there a way that we can take all of this effort and these laws and maybe point trust and privacy more in the same direction?
Could I quickly interject a little comment?
Sure, Raul, go ahead. And we'll do some questions now because...
Really quick one.
Yeah.
So, like in Finland, we were really quite, on paper, we were quite prepared for GDPR. We've had really tough data protection laws since '98. And it was realized that, well, the legislation was pretty much there already, but the companies didn't really abide to it. And now they do, because they actually have a threat of big fines. So that's what really makes them sort of do what they were supposed to be doing for the last 20 years.
Oh, it's true. You have to look at whatever entity you're dealing with and what is the way that you get its attention. And a for-profit corporation, way to get its attention is to go at the profits. So why don't we just move to some questions, since the last question I asked was unanswerable. So we'll go to Johnny in the back.
Thank you very much, Alan, you made reference to the public address. Can you please define it?
I will attempt to define it only if everyone promises to abide by my definition of a stop discussion. No, I can't define it because the general, we spent some time in ICANN a few years ago saying, let's define the public interest. And I always thought that was a really dumb idea, because it goes back in the US. There was a question a number of years ago about how do you define pornography? And the answer was, I'll know it when I see it.
That was Judge Potter Stewart in the Supreme Court.
And if you come up with a definition, you will invariably the next day come up with an example of something that you believe meets the public interest but doesn't fit the definition. So all you can do is come up with some hand waving or examples so that you have some framework to try to make a decision when the new decision comes up. In my mind, there's nothing, you can't do anything better to do, and that means since you don't have a hard, firm definition you're going to work, there's always going to be someone who's unhappy about the implementation when you do it. That's life.
Alan, I think that you're right, we cannot have a sharp definition of the public interest, but at least we should have more or less guiding lines, so that as a reference, so that when we address case by case, we will have something as a reference. But now, nothing is defined, so we speak about public interest, we don't have.
There's another discussion going on in ICANN now that started up again. We'll see what happens. I don't think we're going to satisfy people, because there are so many people in the ICANN community, both people who are in the business or people who are involved in this, like us, that we seem to think we're doing good stuff. And the viewpoints are very different. And the viewpoints of the public interest are very different. And it's very hard sometimes to get, I'm not talking about a specific company, but a large corporation who has its stakeholders and stockholders to consider, to agree to your definition of the public interest when they have competing motives. So it's difficult. I don't think we're going to find a definition or anything close to it.
Deborah, I'm curious, in the circles you normally travel, which are very ICANN adjacent, how does public interest get talked about there, and is there a debate, or is there a definition or an assumption, or what happens around that phrase?
Yeah, I'm not sure how much the phrase is used. It seems like a very, I guess you see it in some spaces, but it does strike me as a rather ICANN-ish term that's debated here. I think we talk about what's necessary in a democratic society. We talk about public goods and about, preserving, I wouldn't say a harmonious society, but yeah, like a democratic society, what types of principles and norms are needed. Public interest, I think we do use it once in a while, but always get pushback that it's a bit subjective, and especially from groups that tend to be marginalized and vulnerable in society, they see that as being used against them, and that it's not in the public interest, let's say, to have these groups have a voice or to be more active, and they tend to be, put in the sidelines. So I think I think if the community using it knows what they mean, then it works like any term. So I think it's a bit challenging if you're working together towards a public interest or any type of goal and you don't have a common reference point.
So it seems perhaps our debate around public interest is doomed because we're not necessarily even using the right term. We're not using a term that we could really pin down, and there may be other ways to define what's good about our goals.
Maybe.
And I guess the concern, if you try to define the public interest as the greatest good for the greatest number, then that becomes a form of majoritarianism, which leaves out marginalized peoples. But if you look at the greatest good for the most vulnerable, then that's another definition, perhaps, goes in a different direction. But then does that mean that we should, redistribute all the income and the property? I don't know. Not today, at least. I can't. At least, thankfully, does not have that power over others.
Let me try to show how difficult the problem is. The UK is deemed to be a democratic society in general. There are probably more surveillance cameras on street corners and things like that in the UK than anywhere else in the world. When you couple those cameras and artificial intelligence, you can track where virtually everyone in the UK, or certainly in the cities, goes from place to place. If you merge that in with credit card data, you know everything they're buying. Okay, so the state obviously thinks having those cameras is a good thing in the public interest because it allows you to have videos when something bad happens or alert you when there's a traffic jam or whatever. On the other hand, they also have the capability of literally tracking many of their citizens moment by moment and putting all that together, if you choose to, in ways that many of us would think are not in the public interest.
Absolutely. And also not in line with democratic
And I'm not
principles.
talking about a surveillance state. You know, you mentioned Syria. I'm talking about the United Kingdom. I'm talking about London. So
It may be that all states
how
are
do you balance
surveillance
those?
states, that's what they do with
well,
it.
yeah, now, but the problem is you're not going to come up with a single definition because the different actors within that environment have different views of what is in the public interest.
And it's often defined by those in
And I don't think
positions
I
of
can.
power.
I don't think I can different than that.
Bruno, we have a question. Bruno in the back, and then
Quick comment. Your question before you open to the audience about how could we use laws such as GDPR to rebuild trust around like privacy and data protection, but maybe Deborah can help me with this. GDPR and data protection and privacy protected law and frameworks around the world, they are the instrument to building trust and to build more, to set up a proper conversation in terms that you limit the activities and you set ground rules and you give just so maybe just that you can enlighten us a little bit about how, to what extent those frameworks are helping us build trust or maybe helping us rebuild trust into the set of discussion, because whenever I hear about data protection, especially in environments such as ICANN, the discussion tends to go towards the lines of GDPR being weaponized or being used as a weapon against businesses, but it's not necessarily the issue, and maybe coming from the side of human rights defenders or human rights activists, we tend to see things a little bit different. So maybe just a little more comments on that.
Yeah, and I think, thanks for the comment, Bruna. I think since we started off talking about end users, right? And if you look at privacy and data protection laws as a way to control your barriers and how you interact with the rest of the world, so how much of your personal life or personal data can be shared with your family, with your friends, with the government, with companies, or with society in general, and data protection, when done right, helps put that control back into people's hands, the end users' hands, to say, this much I consent to, this I don't consent to. Obviously, there's problems with the binary of consent or don't consent, because if you don't consent, you don't get to use a lot of these services. So again, it's not perfect, but when done right, it helps put that control into the user's hands, and then they trust more their interactions with companies, they trust more how their data is being used, and that it's not being misused, and then they can correct it if they want to. I was just at a really fascinating 2-day conversation around gender and privacy with a transgendered woman who was saying how the right to change your information and change your data is so important to her, and how having that wrong in the world is actually re-traumatizing each time she sees it, what she was assigned at birth, her old name, these types of things. So it can really be a tool for empowerment, and I think trust is about how you use your technology and how you interact with those using your data. And when done right, data protection can really enhance that, I think.
The real difficulty in some environments is privacy legislation. GDPR establishes the relationship between the data subject and the company, the organization they're dealing with, and allows them to have some level of trust that the company will not misuse their data. The problem in the internet environment is it is not just a binary relationship. By registering a domain name, which is now available around the world to everyone and can be used in various different ways, means there are other third parties, fourth parties involved in this equation, which were not directly considered by GDPR, which is looking at the binary relationship between the data subject and the entity you're giving your data to. The second order effects of this data being given and what they do, because if you register a domain name, they immediately have to give some information to the registry, which puts information in the global domain name system, and suddenly there are other actors, and that direct privacy relationship did not factor that in. And that's why we're in the world we're in here, because we're managing a global resource with a law which is aimed at a very, very specific interface between the data subject and the corporation they're dealing with. It's a much more nuanced problem than a simple case of me contracting with someone to do something and how they treat my data in a situation where they're using it only internally.
Okay, first we'll go to the gentleman in the back row, and then Marita, and then the back.
Bangladesh. I have two comments and one question. During the discussion I have found from your side. The thing is public interest. We have discussed a lot of more public interest. Actually, who is the public? If you think in related to ICANN, at last people, they are also public. Business and constituency, they are also public. So who is public we are defining? This is the main question. If you define those, all of the stakeholders in ICANN ecosystem which are related to DNS business, all of them are public. But the concern of their interest, all of them, their interest, they show that they are inside things. But my question is, if all persons, those who are individual stakeholders, since they are all are public, they are equal in this ecosystem. I think they are not equal to represent. The second thing is the trust and privacy. You know, the recent, two or three days ago, see it in news, I read a newspaper, a big giant company has agreement with third party to their privacy service they will handle by third party. I do not put the company name. I found the newsletter and see the news. So if that I support the GDP one sense that big giant companies might take some responsibility and take some ethics from the individual customer. They do not manipulate the data, do not sell the data without their permission. So there should be some ethics and there should be some restriction, and there